The Appellate Division First Department is now in session. Good afternoon, ladies and gentlemen. My colleagues and I welcome you to these virtual admission ceremonies. Ms. Schwartz, I would ask you to please proceed.
Good afternoon, and may it please the court. I, Sharon Schwartz, staff counsel to this court's Committee on Character and Fitness, am honored this afternoon to present to the court 25 applicants for admission to the bar. Further, I am pleased to report that the committee has examined the records of each applicant appearing here today. Accordingly, on behalf of the committee, I certify that each applicant appearing here this afternoon does possess the requisite character and fitness to merit admission to the bar of the state of New York, and therefore I do hereby move for their admission.
Thank you. Before the court rules on your motion, I want to take this opportunity on behalf of myself and my colleagues to thank the members of the Committee on Character and Fitness for the excellent job that they have done to ensure that the candidates that are being presented here today are well qualified for admission to the bar of the state of New York. The committee's work is very important. They honor us by serving pro bono, and their work is greatly appreciated. I'd ask you to please convey this message to the committee members if you would.
I will, thank you.
Thank you. Now we turn to the motion that is before the court. I'd like to remind everybody that Justice Cardozo famously said, "Justice delayed is justice denied." And one thing we won't be doing today is denying justice. My colleagues have authorized me to rule on the motion forthwith. It is granted. The oath of the office will now be administered by Margaret Soa, the clerk of our court.
Good afternoon, Justice Gish. Good afternoon, candidates. Please raise your right hand. I'll recite the oath in the form of a question. When I'm done, I will ask you to unmute your mics and respond by saying, "I do." Do you solemnly swear or affirm to support the Constitution of the United States and the Constitution of the State of New York, and to faithfully discharge the duties of the office of Attorney and Counselor at Law according to the best of your ability? Please unmute your mics and respond by saying, "I do."
I do.
I do.
I
do.
I do.
Congratulations, attorneys. Please remute your mics and you may put your hands down.
Congratulations. Well, now you are officially lawyers. And at this time, I'm going to ask my colleagues if they would please unmute themselves so we can give you your deserved round of applause. It is our custom in this court to have a justice give some welcoming words to you on this important occasion. And today that honor falls to Justice Moulton.
Thank you, Justice Gish. To all the new lawyers in this virtual room, congratulations. 34 years ago, I was admitted in the first department. I don't remember the justices who were present that day. I do not remember much about the remarks of the justice who addressed us newly minted lawyers. I do remember asking myself, when is that guy going to stop talking? So I will be brief. You're joining a vital profession, one that is a crucial component of a well-ordered society, and it needs good people to run properly. You are literally our newest recruits. Our legal system, along with similarly independent legal systems in a handful of other countries, is the envy of the world. A majority of nations probably do not have the rule of law as you and I understand it. They do not have they do not have fair, fully functioning legal systems. By contrast, in New York City in particular, our state and federal courts are a destination for commercial entities from around the world who, if they must engage in litigation, wish to do so in a forum free of political or commercial biases and that renders decisions in a reasonable amount of time. Indeed, corporations around the world often write into their contracts forum selection clauses that designate the commercial division of Manhattan Supreme Court as the court where any litigation arising from the contract will go forward. The importance to business of a fair and impartial legal system cannot be overstated. Without it, businesses are reluctant to commit capital and take risks. Our legal system has also been a means for moving our nation forward on civil rights. For those of you, probably the majority, who are fresh out of law school, cases such as Brown versus Board of Education, Estelle versus Ruiz, Gideon versus Rainwhite, Frontiero versus Richardson are fresh in your minds. Perhaps you read biographies of lawyers who changed aspects of our legal system for the better, such as Pauli Murray, Thurgood Marshall, and Ruth Bader Ginsburg. Perhaps you take inspiration from them. However, you should never, ever consider our legal system to be perfect and immutable. Our legal system is a work in progress, and you all have a role in changing it for the better. A moment ago, I spoke about how well we do in commercial litigation and how we attract the world to our courts. However, other aspects of our legal system are sorely in need of attention and resources. Poor and working class people often have no access to a lawyer in civil litigation. In criminal courts, our assigned defense counsel do an often heroic job, but they're overworked and under-resourced. Having no lawyer or an overwhelmed lawyer is a disability in seeking a fair outcome. Economic status should not determine outcomes in our courts, but too often it does. Obviously, there have been times in our nation's history where lawyers have played a malign role in perverting our legal system. Joseph McCarthy was not a lawyer, but he was assisted by very able lawyers in his red baiting. Lawyers working for large corporations have, on occasion, gotten away with criminality in obscuring the health effects of dangerous products. Prosecutors have, on occasion, acted to enforce white supremacy in our criminal justice system. The imperfection of our legal system is reflected even in the First Department's beautiful courthouse. If we were sitting in our courtroom right now, you might look up into the stained glass dome at its center. You would notice the names of a number of legal luminaries. However, that cupola also contains the name of Roger Taney, the Chief Justice of the U.S. Supreme Court who wrote Dred Scott versus Sanford, in which the U.S. Supreme Court held that the privileges and immunities of the U.S. Constitution do not apply to African Americans, whether they were enslaved or free. The presence of Taney's name in our beautiful courthouse is a reminder to me of our imperfect legal system and how all of us as lawyers must work to improve it. How can you do that? First, you should do pro bono work for underserved communities. That's truly a win-win endeavor because it will simultaneously help out someone who needs help in a landlord-tenant dispute or a criminal matter or a consumer debt case, and it will give you hands-on legal experience and greater responsibility than you might have as a young associate. Second, you should join one of the numerous excellent bar associations that exist in New York City. A bar association's very mission is to improve aspects of the profession. In sum, remember that you are a member of a vital profession that can be an immense force for good. Act with integrity, with intelligence, and with heart. Good luck.
Thank you, Justice Moulton. At this point, this session of the Appellate Division is now closed. Good luck to all.